Hello, Ohio Sherm. My name is Lou Lessig, and I'm here for your value-added time here virtually. In fact, this session is only available to you in your virtual bank, and I hope that it gives you not only a credit, but some truly insightful information. You see, this is one of my top programs of the year, and in fact, it was done recently to all sorts of folks that were incredibly happy to see it. So I'm hoping that you enjoy it as well. In fact, I have an added bonus for you. Hang until the end. And I'm always trying to up my game. So if you saw the wake up program to remove emotion from retaliation, you know that I'm always trying to up my game, always trying to get better. And that's exactly what I'm trying to do as well in this session. And so towards the end, I will ask you to just take a minute and a half or so just to provide some feedback so that I can get better, so that I can deliver more impactful information to audiences just like yourself. However, right now, we're going to start taking off for our top 10 cases. Now, normally what I would do is I would have the opportunity to have everyone engage via live polling. However, that's not actually something that we can do here because, of course, this is recorded. So normally what would happen is people would text in their stuff and then Poll Everywhere would pull them into the session so they would be a part of the proverbial action. Now, admittedly, while that may not be something that is an option for us, I can tell you this. I will be sharing with you all that information. You will miss or lack for nothing other than the fact that you may not have an opportunity to know what everybody else thinks, but don't worry, because I'm going to let you know what almost 500 people just like you thought the last time I gave this session. So let's hop right into it right now. We're going to deal with, oh, and by the way, in case you weren't really sure, I am a full-time employment litigator, which means I try cases, I deal with agency stuff, all sorts of things. I'll give you information in terms of how to find out more about me. But my point is, I'm not just a talking head, and I'm not just like every other lawyer. And in fact, if you haven't been able to figure it out right now, the number one thing that people say about me when I talk across the country is that I talk too quickly because I'm from the Northeast. All right, so now we're in Ohio. I'm going to slow down a little bit. If I talk too quick, normally what I would tell you is that you can let me know and I'll slow down. Obviously, kind of hard in this scenario, but still going to deliver for you. So let's give you some very, very interesting cases. I'm going to give you the facts. I'm going to let you know what's going on, and I'm going to tell you why you care, a practice pointer, if you will, for every one of the top 10 cases for the year. In fact, if the case is from a particular circuit, I'm going to let you know what circuit that is and the states that are covered within that circuit as well. Hopefully, again, all about teaching you something new, hoping that you enjoy the opportunity to spend some time together today. Let's go to our first case. Now, this case is unique, more unique than any other case you're going to hear about from me. In fact, it started last year because this case was actually originally filed last February. Now, here's the interesting part about it. It is, contrary to popular belief, the first, let me try that again. It is the first case in the country dealing with AI, and more specifically with the algorithms utilized in vetting new potential candidates. So here's what we have. In fact, this case, unlike every other case you're going to hear, has been decided. This is an active case. It's such a big deal, such cutting edge law. I'm bringing it to you now as the very first case that we're going to talk about today. Can you tell I'm a little bit passionate about this stuff? This particular matter, though, here's what it was about, okay? Or it is about. Title VII, it's all about an individual. Mr. Mobley actually is a Black gentleman who's over 40 that has anxiety and depression. Now, I share all that because you can see why all three of those federal laws are listed here. Now, admittedly, if you can't tell, that's the Northern District of California, which is where this is venued. Not surprising, given some of the things that happen there. But here's the scenario. Mr. Mobley has brought an action asserting that Workday, which is the company that his employer or prospective employer was going to use, or actually did use, that the way that they structured their algorithm was adverse to Black individuals, to people over 40, and to individuals that have certain types of disabilities. And the complaint was not particularly well written. And so the first thing Workday tried to do is they tried to boot this thing. The argument, of course, being, look, we don't really have any horse in the race of whatever our clients use the stuff for. Mobley's counsel came back and said, look, This is all about recruiting and hiring and how stuff is done on the front end of the employee life cycle. And the bottom line is, if the algorithm is bad, I mean, it's no different than if we have a bad HRIS system. Well, do you have a bad HRIS system? Or is it that you're taking bad data, putting it into the HRIS system? So what are you getting out? Bad information. Now, recognizing all this stuff is going on, the challenge, of course, comes down to what does the complaint look like? And what ended up happening is there's this question about, was there an adverse impact by the way in which Workday designed the algorithm for their platform that Mobley's prospective employer and other employers were utilizing? The issue comes down to this. Workday makes the claim that, in fact, they haven't done anything wrong. They just create this tool and they put it out in the world. And the challenge is that there's some question. They try to get this thing thrown out, and the court's like, well, you know what? We're not so sure about this, because the complaint only deals with one component, basically asserting that you're an employment agency, and by the way you're utilizing your platform, and therefore you're gaining information and utilizing in such a way that it could be adverse to prospective candidates. Now, they take a look at that. The plaintiff sort of put stuff in the complaint, but there was an issue there. Court actually gave them time rather than just kick the can. The court said, well, wait a second, let's take a look at this a little bit more. It's cutting edge technology here. And the issue becomes, well, which one of the various areas that you're trying to claim, plaintiff, are you actually claiming? You see, on the one hand, you could make the argument, like you did, that Workday is an employment agency. You could argue that they're an indirect employer because they still are involved in the process. Or you could argue that they're an agent of the company because the work that is done by Workday's program is work that the employer would have to do, or their Workday's client would have to do anyway in order to find their candidates. Whatever the case may be, the issue becomes, hey, we're not so sure that this really works. And by the way, parenthetically, there is a notation at some point that Amazon, small employer, did away with their AI in this area because they found that it was actually adverse to women. But in any event, different program altogether. Let's deal with what we have here related to Workday. I should also mention that the EEOC even filed an amicus brief, meaning that the EEOC favored Mobley in this lawsuit and asked the court and filed a brief supportive of Mobley's position. So they get this new complaint filed, and now, rather than a bare bones kind of complaint, which many complaints are, this one, at the sort of indirect direction of the court, now is all involved in talking about how they're acting as an agency, how they're acting as an employer, how they're acting as an indirect employer or an agent of the employer. And they have included a lot of the information, of course, during this process. Mobley's made it a real point to say, by way of motion, that, look, you know, they've got this algorithm, they've got this AI that they're using, there are no guardrails on it. And the problem is, it may even be that the thing will learn, and they call it drift, where it learns from itself and sort of gets a little far afield of where it's supposed to be. But because there were no guardrails set up with the Workday program, it really created a problem. Now, the interesting part here is that the court is being very engaged. Sometimes you find judges that just say, look, let's just move the case along. Here, there is a thought process, it seems, from the bench to truly roll up their sleeves and see what they can do to really make this happen. Now, Workday, of course, the new complaint got filed, the amended complaint, and now Workday has renewed its motion for dismissal. And the interesting part is, at this point, here's where we are, the decision is actually still pending. And there's still a lot of gamesmanship going on. I mean, this is big money. But from an HR perspective, from an employer's perspective, there's a lot that we can learn here, because what are we talking about? We're talking about cutting edge technology that, in fact, has built-in motivations and consciousness and questions about discrimination around the algorithm based on how humans have programmed it. Where else might you see that in AI within your organizations? So while this stuff is still pending, I will say this: if there's no other case in this group that you remember, take a look at and follow after you're done with this video, I would by far follow Mobley more than anything else. Now, from a practice perspective, the thing we need to realize is the reason why Workday is even involved in this with their prospective clients and plaintiffs like Mobley is that what are the licensing agreements or other vetting agreements between Workday and their clients? And if you're going to be an organization where you're going to utilize some of this work, you've got to take a very, very hard look at all the red tape and all the legalese that's, in like half point that no one can ever read. Well, friends, this is a place where you need to read it, because guess what? If there's indemnity language and you get dragged into one of these lawsuits for just some off-the-shelf program that you wanted to try out because you thought it would save you time, maybe it's worthwhile to step back and think twice. Little food for thought. Now, of course, AI is a very interesting thing right now, and I have been asking folks how much they utilize AI, but more than that, sort of the precursor, how many of them actually have a policy related to AI. And this is what folks had said as recently as within the last 60 days. Now, I don't know if this is you, but I will say this: if this is a concern of yours, I would certainly take the time to figure it out, because this is the time where we as organizations need to appreciate what our workforce is like. It's almost as if we need to do two things. We need to educate them on what AI is, and we need to educate them on how they can properly utilize or not AI within the workplace. More stuff that can be done, certainly stuff that we've been talking to clients about, should you need assistance there at some later time. Now, at the same time, we have to appreciate that the ADA is really in a state of flux as people try to delve into it. And it's an area that is particularly problematic for employers, whether we're talking about training that's done, whether we're talking about how people consider things and look at stuff. And that's really where our next case comes into play. Let's talk about Jones versus Georgia Ports Authority. This is out of the 11th Circuit. You'll see that includes Florida, Alabama, and Georgia. I know it's not Ohio, but there's a point to the story, so bear with me in terms of case 2. Now, this case is all about something that may be near and dear to your heart, so let's see, because it's all about ADA paperwork. In fact, this deals with an individual who is an Army vet with PTSD. The challenge comes in that he's been a 24-year employee and originally took leave because his supervisor he viewed it, bullying him, harassing him a bit, took some time off. And the Port Authority has a very interesting policy, probably not unlike yours, where what happens is this: you have to be able to, if you're out for more than 3 days, you get a doctor's note that clears you with no restrictions and allows you to come back to work. Now, here's what happens. The Port Authority sends Jones the paperwork. Jones gets the paperwork. The paperwork says that he's going to continue to seek therapy. The paperwork, contrary to the policy, also is not signed by any medical professional at all. And so the challenge that comes up is the doctor's note doesn't actually say what the policy requires it to say in terms of a full release of duty with no restrictions, and it wasn't signed. Now, I know what you're probably thinking. What's the big deal? You're right that the Port Authority could have taken the position of, hey, let's try to figure this out. Let's reach out. Let's find out something. But they don't have to have that requirement because there's nothing in the policy that requires them to do it. And they didn't. Now, ultimately, they reach out and they say, look, you haven't signed anything and you're not compliant. Took a look at things. We're not sure when you can come in. And so we're going to let you go. Jones, of course, turns around and files a lawsuit, and the district court grants summary judgment. And when they grant summary judgment, they basically say, look, the policy is the policy. You didn't follow the policy. End of story. Goes up to the 11th Circuit. 11th Circuit takes a look at it, and here's where life gets interesting, because the 11th Circuit, in fact, continues. They go on and they say, listen, we're going to affirm the summary judgment, and we're affirming for 2 reasons. One, you have to appreciate the fact that at the end of the day, the policy requires a signature, and you didn't get a signature. It also says that you have to be specifically released to duty. Neither one of those things was there in violation of the policy. And oh, by the way, there's nothing in the policy that requires the employer to do something further. The employer gave you the leave. You were on protected ADA leave. This is a requirement to come back to work, and how that happens. Now, what ends up from the court is this idea of having a clear policy violation. Now, at the same time, we got to think through, well, what does this even mean? I got to be honest, I find it fascinating, but at the end of the day, if you've got a written policy, you want to make sure it's followed. I know what you're thinking. Hey, we have a vet here. We want to try and take care of them. We've got a policy, but you know what? We can waiver a bit. Listen, this is the poster child case in this top 10 list to have you think about, what does the policy say? Why do you have it? And how do you make sure that you protect the policy and the methodology upon which it was drafted? Little food for thought for you. Now, let me ask you this. I want to talk to you about social media for a second. It's also been an issue that's come up for employers a lot. And I asked everybody in this session, one thing as part of the poll everywhere. I said, listen, social media is a fundamentally different medium to share information that has its own rules of enforcement and standard of care. True or false? This was the result that people came back with. And by the way, this is not unusual. In fact, this happens all the time. That's why I love this question. You know, it lets people know, like myself, that, hey, maybe I designed a question the right way, because it's 50-50 in a room of 500 and some odd people. That's great. Now, here's the reality, and I'll share with you exactly what I share with audiences around the country. At the end of the day, I will agree with you that social media is a different medium, right? It's like this, it's virtual. But guess what? All the laws that we utilize to address social media, Title VII, ADA, ADEA, they're all core to what we do in our day jobs within our brick and mortar stores and locations. So while it is a fundamentally different medium, the rules of enforcement are no different, nor is the standard of care. For that reason, the answer here is false. All right, let's take that thought process as we move into our next case. Another fascinating case for you. It's the Department of Labor versus Bevins. Now, here's what happens here. We have this matter, and originally, the issue comes up where Bevins is a moving company. They have an issue with how some of their folks are paid. There's one particular individual that feels like he's getting screwed, and he starts talking back to the owners and basically saying, look, you're either going to pay me correctly for my overtime, or I'm going to turn around and I'm going to go to the labor board. And the first couple of times they sort of give him some garbage and they go back and forth a little bit. But at the end of the day, it ends up that they're a little more pushy. Bevins has sort of had enough. They fire the guy. Like, enough is enough already. Do what you're told. We do the right thing. Move on. So what does he do? Plaintiff obviously turns around. And by the way, his name is Bacchus. Bacchus does what you would anticipate. He goes to the labor board. Shocking, right? So he goes to the labor board, and he doesn't get money back for himself. He gets money back for 17 of his fellow employees. What becomes fascinating about this is that that case is settled. The Department of Labor works out with Bevins. They get it done, completed, what have you. Then the Department of Labor puts out a press release. And in the press release, they say that they have, captured overtime violation amounts against the Bevins company. On behalf of 17 people, here's the amount. Nothing else by the Department of Labor. But then a local TV station picks up the matter. And when they pick up the matter, they don't talk to Bevins. They only talk to the plaintiffs. Bevins, one of the owners, gets upset and responds online to what they do. As you can imagine, suit ensues based on what was put online. And the Department of Labor is now seeking to get some things done. Bevins turns around and files a motion to dismiss, claiming First Amendment rights. So this is in essence a motion to dismiss. However, here's what is so interesting. The underlying matter that I shared with you, well, it wasn't like it was that much money. And yet that wasn't even the core of the issue. The issue was all about what did the local TV station do? How did they handle the situation? How poor did they address the situation? So, here's the interesting part. I want to share with you a piece of what Bevins posted online. Now, the interesting part as you take a gander here is that not only did Bevins balk, and this is only part of it, by the way, not only did Bevins balk about the fact that the TV station never talked to them, but it encouraged individuals to take a look to see what this guy did. Oh my God, can you believe how we're getting stuck? And it's really not fair. And it goes on, by the way, the portion that isn't here, because I want to make sure you can read it on the screen, is that it cost them another 17 grand to deal with this issue. Interestingly enough, though, this whole matter is a motion to dismiss. It's all based on we're still talking about this idea around First Amendment, whether it's going away, the Title VII concerns and FLSA concerns. And the court takes a look at it and says, wait a second, your motion to dismiss is denied. And the reason why it's denied is this: your actions of affirmatively going online and balking about the settlement that was worked out, well, that creates a chilling effect. It may convince the next person not to actually come forward. And because of that, we're not throwing this case out against you. No, you're going to have to move forward. And what this case tells us is very simple. There's a time and place for everything, but it's not just in the movies. Truly, silence is golden. You need not respond. Whether you agree or not, there are other ways to do it. There are reasons why we have PR firms. Little food for thought there. Now let's move on to our next case. All right. Now, the question I asked everybody, in your organization, who handles FMLA leave issues? So we're assuming, of course, at least 50 employees. This is how everybody came down on it. Now, of course, it becomes a bigger deal because you have to consider what our next case is like. And so we'll hop into that right now. Ladies and gentlemen, welcome to Sarita versus Blue Cube. This is an interesting matter. It all has to do with FMLA interference. And what happened in this case, plaintiff basically is working, turns and says, hey, listen, I have an issue. My ailing father needs care. And so I don't need time off, but I'm going to take my lunchtime and go. He lives locally, help him out and come back. Employer doesn't say anything. And now time passes. Now the employees start balking at Blue Cube and say, wait a second. Are we working here? Or are we working for her dad? Because she's not taking a half-hour lunch. The lunch is much longer than a half hour. There's no clocking out. There's no clocking in. All that stuff is required. What's going on here? In fact, at one point, there was a discussion about parental leave in the hallway with HR, who said, listen, if you need FMLA intermittent stuff, let me know and we'll get you the time. Sarita sort of blew HR off, said, nah, don't worry about it. We'll talk later. I'll think about it. I'll get back to you. Now, that passes. Some point later, one of the managers, because everybody's still chirping, goes to her and is like, listen, it doesn't make any sense. You can't do this. And in fact, it's a problem because you didn't accurately record your time. You didn't clock out. You didn't clock in. You didn't tell us what was going on. You never took the FMLA, even though HR shared with you that you could. And we went back and looked. Do you have any idea how much time you basically stolen from the company because you didn't properly do things and didn't seek the time? Of course, it was a blank face in response because that time was 99 hours of time. Think about that. So, of course, they fire her. She then files suit for interference. And looking at the facts, Fifth Circuit comes down. They affirm the summary judgment. They basically go on and said, listen, the plaintiff has an obligation to notify the employer what the issue is and to avail themselves of the protections, particularly when the employer gives them the option to do that very thing. Can't make this stuff up. But what it does also lean into is the fact that we have to make sure that we have organizations where policies are properly put together, not necessarily externally, but internally, and training done so that your supervisors and your HR professionals are very focused on making sure that people are aware and avail themselves, if it exists, for whatever the protection may be. However, you don't want to have a situation like this where, hey, we offered it, but they didn't properly avail themselves of it. You can lead a horse to water, but just saying. All right. Of course, the next question becomes one as it relates to conducting interviews. We talked a little bit about algorithms before, but this time I wanted to ask folks, if you're conducting interviews virtually, do you know how much data is being collected in those interviews? I found the response here fascinating because by and large, folks have no idea what information is being recorded because they're only focused on it from their discrete perspective. What information are they getting? How are they trying to operate? What are they doing? That's it. And yet there's so much more. Utilization of new technologies and AI is all the rage now, and everybody's talking about it. But as I regularly talk to people about AI, it's much more involved. It's much more focused. We have to start looking at more things than just recruiting, more things than just, are they telling the truth on their resume? Are they actually sending us an email, or is it their avatar that's sending it to us? And are they really thinking about that? But the truth is, technology leads into very interesting places like our next case. So let's go. We're going to go there now. HireVue is a very interesting case. Here we have 6 individuals who all brought an action against HireVue, what they claimed. And now this is interesting because it is based upon a state law in Illinois. I bring it to you as one of our top 10 because it is truly cutting edge stuff. Let me tell you why. It's based on the Illinois Biometric Information Privacy Act. All right, so what kind of information is HireVue collecting? They bring an action because HireVue takes a position, look, like Workday, which you might recall from an earlier case, they had the opportunity to go through stuff, take a look at things, gather stuff, make their program. They call it an out-of-the-box deal. You take it out of the box, you plug it in, and it goes. But is it really that simple? You see, the plaintiffs assert that, wait a second, your stuff is coming out. You're telling us that employers can purchase it and use it, and there's no back and forth. And yet, as you develop the software, it's learning. It's gathering information. In fact, it's collecting all sorts of biometric data as it's watching candidates respond. More than that, and this is somewhat amazing, I think, to some folks, according to HireVue, there are literally thousands of different data points that it's gathering in nanoseconds of people doing this stuff, which I presume is somehow getting back to HireVue to make the program better over time. And their point was, look, you never told us you were doing this. So the 6 plaintiffs were like, look, if you're going to do this stuff, you got to tell us. If you don't tell us, then you're violating our privacy and you're violating the law, and it's a whole issue because you're sort of hiding the ball. Interestingly enough, court takes a look at it. And as they looked at what the claim was against HireVue, they basically said, look, the thing is, this case is going to go forward. It's going to go forward because we don't know at the complaint stage, because a motion to dismiss is before any discovery has taken place. We just don't know where this technology is going. It's so new. And the way you're capturing stuff, we're just not sure between your marketing materials and our understanding of the process, trying to figure out now, have you really failed to state a claim? We just don't know. And, if you think about it, the question here is the 1,000 points of data, right? In whose possession is it? If it's a server for HireVue, well, doesn't HireVue actually have possession of that material? And doesn't that then, without notice to individuals, doesn't that violate the law? And now you begin to quickly understand where the challenges are. So it's creating a bit of a challenge. Discovery is obviously continuing. And from a practice perspective, what becomes important here is, if you're going to do these kind of interviews, and if you're going to handle them in a particular manner, you have to consider the transparency to the candidate, what you're telling them, and how thoughtful you need to be about the entire process. Again, you can't stick your head in the sand like an ostrich. You have to appreciate what's going on in order to know where all that data that you are either inadvertently or overtly collecting, where is it going? Okay. Now, I did want to ask, because I think this is particularly relevant in this cycle that we're in right now. in a word, if you think about Title VII, how can an employee be harmed by their employer under the law? That's a question I asked before I went into the next case. And the result was this particular word cloud. Now, if you take a look at this, what you find is certain things that are totally appropriate, right? Biggest thing being discrimination, followed by retaliation, not a surprise. Other section to take a look at, wake up, taking the emotion out of retaliation. Part of the reason for that is the fact that retaliation is a big word right here. That's why I came up with that particular session that you're going to want to check out if you haven't already. Now, when you take a look at some of the other things that are going on here, I find it fascinating because so much of the inequity or slander or ageism or prejudice or defamation, all of those things get wrapped up under Title VII. All of those things are the kinds of issues that we have to deal with. Things that we have been dealing with in a particular manner. But my friends, this is another one of those cases that is about to take everything that you know and turn it on its head. Ladies and gentlemen, welcome to SCOTUS, the Supreme Court of the United States, and a decision in Muldrow versus the City of St. Louis. Now, if you don't know about the City of St. Louis, let's just start from the perspective that, yes, this is a Title VII case. But here we have an individual who was a female officer, who was a sergeant in the St. Louis Police Department. And more than that, she had this amazing position in a department that was a specialized intelligence division. In fact, she had FBI credentials. She had the ability to do investigations beyond the city of St. Louis. She would have the chance to rub shoulders with all the muckety mucks in the police and some of the feds as well, and truly gave an eye-opening perspective beyond the city of St. Louis. Everything was fine till a new supervisor comes in. That new supervisor, what does he do? Well, it wouldn't get this far if he didn't do something, right? He decides that she would be better being in a different department, running a different group of folks, not in the Special Intelligence Division, but in a normal, like, patrol division in one of the precincts within the city. And he also thinks that a man would be doing a better job than she would. He takes her out of there. And even though she doesn't agree to the transfer, they transfer her. No change to her title or her salary. And while she doesn't request it, as I said, they still did it. What begins to become problematic is that while she's doing the job, she's not getting a lot of the perks I mentioned to you earlier. There's no interaction with really cool people. There's no opportunity outside of the city. There's no FBI credentials. There's no fun. In fact, she was plain clothed, and now she's got to wear a uniform every day. And it wasn't her choice. And, some of the issues that come up, interestingly, are challenging because, again, there was no change to her salary or to her title. But she files suit based on the transfer. District court dismisses it. And they basically say, look, there was no significant harm. Who cares? It should be no big deal. The true level of your injury wasn't really enough to bring the claim. They dismissed the claim. Of course, it doesn't stop there. It went back up. It went all the way to the Supreme Court. Ladies and gentlemen, if you have only been partially listening to what I have to say today, this is one of those times where you need to listen. This is a big deal. This is a really big deal. This is such a big deal. It's part of the value-added stuff you're going to get at the end of this session. So stay tuned. Here we go. The Supreme Court came down and basically said, guess what? The last time we checked, your summary judgment thing, that's chucked out the window. MSJ, motion for summary judgment. We're reversing that bad boy. And the reason why we're reversing it is because we've been through Title VII. And guess what happens when you take a look at Title VII? There is not a scintilla, not a single place where it talks about anything related to significant harm. That is not the standard. You need some kind of standard, but you don't need significant harm. The district court was wrong, and so they reverse. Now, this is the practice pointer, or one of the practice pointers, that you really need to pay attention to, because, ladies and gentlemen, this is about to take all the law that we've talked about for, pretty much my entire career and turn it on its head. because now we have a brand new standard. We have no idea what some harm is. What does that mean? I'm not really sure. And the place where it's going to get worked out, well, that's going to be in the courts around the country. That means we're going to have a lot more things, plaintiffs' attorneys pushing the envelope in this space. It may mean that your investigations become much more important. And so for those of us who do those investigations, have to be much, much more focused to address this harm question, because it's no longer a higher threshold. It's something else that we have yet to figure out. I'm sure you're concerned. I'm sure you're saying to yourself, what does that really mean? I will share with you a little bit more about that in a few moments, but I will say this. You need to be much more expansive in your view, and so do all your managers, in terms of what may or may not be covered under Title VII as a result of this decision, particularly in the employment space. All right, now let's shift a little bit out of Title VII. Let's talk about a little bit of ADA, and let me ask you a question. When we talk about the ADA, who makes the call in your organization about a reasonable accommodation? Thankfully, at least recently, more than half the people asked said that they were the ones making the call. But that's not always the case, friends, as we all know. And it creates a challenge that comes up in our next case that is, oh yeah, right in your wheelhouse, Ohio. So stay tuned. Here we go. Let's talk about the Yannick case. Now, Yannick is a situation where we're dealing with the Kroger company. I know we all know what Kroger is. And the challenge is this: we have a 15-year bakery manager who finds out that, she needs to work on some of her stuff. That's fine. But through the process of her work, she finds that she has breast cancer, and she goes out for treatment. Goes out for 4 months, has her treatment, comes back, returns without restrictions. She's back for a week, okay? And there are certain challenges, and she says, she goes to her then manager and basically says, look, with her union rep, and says, hey, I'm having a tough time. I haven't worked in 4 months. I just put in a 53-hour work week, and I'm hurting. Like, it is hard for me to do this job. And her manager turned to her after hearing this and said, you're not cutting it. Either you go back to being not a bakery manager, but a bakery employee, or maybe you need to go find another line of work, or maybe you need to go to a different area. But you got to figure it out. And the supervisor is pretty harsh on her and continues to ride her. Ultimately, about a week later, she stepped down, ended up working at a bakery as a clerk in a different Kroger with a lower salary and obviously less authority. But she felt that the manager had really ridden her into the ground and she had to leave. She, of course, later filed suit. District Court grants summary judgment for the employer on all counts, saying, hey, you can't cut it. Bye-bye. End of story. But it goes up to the Sixth Circuit. And when it's up at the Sixth Circuit, they took a look at it and they're like, wait a second. It isn't that simple. The failure to accommodate issue, which was one of the claims that she sued on, yeah, that bad boy, you're going to go take a look at that, because let's be honest about what we all know about the ADA. You actually don't have to provide I need a reasonable accommodation. That's not what's needed. The only thing that's needed is some level of understanding, some amount of, I think they may need something, and having to meet them halfway, interactive process, which is why we do this stuff. And so the court's like, you didn't accommodate her. You pushed her out. She'd been out for 4 months with, not for nothing, but she had, breast cancer. Comes back. She's working a 53-hour work week, and she's carrying these 50-pound bags of flour as a manager. Like, what? There was nothing you could have done to help her? Just not buying that. Now, this begs an interesting question, one that we talk about a lot, one that I know I personally do it a lot for clients, which is doing the training, sitting down, talking about what is a reasonable combination? How do we go through the interactive process? How do we do this? How do we recognize these things? The Sixth Circuit was pretty clear that it's not enough to have things happen this way. Hopefully you too can learn about this from the perspective of not having it happen to you. All right. Now let's talk about some employee theft issues and a little bit of FMLA with our next case. Here, Miss Bethia was an assistant park manager for the city of Indianapolis. One of her roles was to pick up donations and take it to the food pantry. Turns out that sometimes she did such a good job in getting donations that there wasn't room in the city. So she and her husband, he went with her a lot, even though he didn't work for the city. They would store it at their house and then, from there distribute stuff. Now, in the midst of it all, she goes out on a medical leave. She goes out on medical leave for her own health issue. And while she's out, there's a claim raised about where are all these donations going and why is it all going to her house? So, of course, you know what's going to happen here, right? They bring her in, they cut her loose. She turns around, she files suit saying, hey, I was protected under FMLA leave. You're interfering with my FMLA leave and coming after me for this food bank stuff, like, doesn't really make a whole lot of sense. And yet the city has to deal with the fact that they have somebody who reach out to them with pictures and say, look, this lady's collecting food in a city car, take it to her house. The challenge, of course, comes in because the court takes a look at this and says what we all probably know, which is, look, your most for summary judgment city is granted because Miss Bethia doesn't get any more protection while she's working full time as she does on her FMLA leave as it relates to issues like this. So guess what? Bye-bye. In fact, it's both on the interference as well as on the retaliation component because it's the same concern. And at the end of the day, if you don't get any more protections, then guess what? You are, well, in this scenario, you're somewhat out of luck. Now, the other challenge here was that the investigation into this was somewhat delayed because of her FMLA. And the truth is that hampered the city a bit. And so the issue here is not so much about what is or isn't protected, but it's more about making sure that those investigations take place. Even if somebody's out on leave, it still has to be done independent of whatever else is going on. I mean, that's no different, right, than having somebody say, oh, wait, I think we need to get a bad evaluation. So before I get my bad evaluation, I'm going to give some trumped up discrimination charge against my supervisor so that they don't actually come after me. Yeah, we all know how well that works, right? Yeah. Well, let's talk about some of those investigations. Let me ask, think about it in your workplace, when you need to do an investigation into claims of discrimination, who does that in your workplace? Is it you? Is it somebody outside the firm? Maybe you have someone completely entirely different. This is what most folks said, which I thought was interesting. Interesting because there are scenarios where you want to make sure that that investigation is confidential, and it's not if it's done by HR. It may be if it's done, for example, by a law firm outside. Trust me, been doing plenty of those these days. And I'm going to share with you a case that I will tell you right now is likely to make you squeamish. Of all the cases that I talk about in this year's top 10, this is by far the one case that I found most upsetting. So let's talk about Copeland. This is out of the 11th Circuit against the Georgia Department of Corrections. Now, while this is a Title VII case, it is not the kind of case for the faint of heart. Here's what happened in this one. We have a sergeant who works in the prison system. Yes, that would be Copeland. Copeland is a transgender man. In fact, Copeland was born a female, holding himself out as a man. During the time spent for the Department of Corrections, Copeland has begun the hormone therapy, the legal change of name, the living openly as a man component of the transitioning process, which of course also requires disclosure to your employer of the change. Copeland goes in to meet with HR, gave them the name change materials. HR refused to accept them. HR said that it was required that they have a birth certificate in order to change that information. So Copeland did that as well. Then it went up to the director of HR, who at one point was on the phone with Copeland and said, "Did you have the surgery yet?" Copeland responded and said, "That's none of your business." As Copeland realized that the director of HR had Copeland on a speakerphone and there were people on the other end in HR openly laughing. It was at this point that Copeland was directed not to use the men's room. Over the course of the next year, there were not one, not two, but 34 different coworkers, all of whom, in one way, shape, or form, harassed the plaintiff. Things like calling Copeland ma'am or baby girl, or otherwise undermining his authority. In fact, at one point, Copeland went to HR, filed through the complaint process about harassment. Nothing happened. Literally nothing happened. Ultimately, after all of this abuse, Copeland did bring an action for hostile work environment. And the district court dismisses the case. They dismissed the case saying that it wasn't severe or pervasive enough, didn't happen often enough, or was so bad that it should go anywhere. Think about that. Goes up to the 11th Circuit. The 11th Circuit says, hold on a second, this is not the way this works. You have to look at not one discrete situation, one discrete conversation, but the totality of everything that happens. And when you look at it from 34 different people, everybody in HR, supervisors, and everyone else alike, totally going after Copeland, there's no way that this doesn't meet the threshold, and sends it back for a further decision based on those facts. Now, certainly things have to be objectively addressed and reviewed. Copeland even went as far as to make that claim, but the investigation was never done. Ladies and gentlemen, I recognize I'm talking to a group of HR individuals who are all probably just as offended as I am. And for the record, my undergrad's in HR, but outrageously offended by what HR and all of their people did, not advocating for Copeland the way the law requires. Needing to ensure that those investigations were done independent of that. And by the way, while we're at it, let's think about the fact that, remember that Muldrow case that we talked about from the Supreme Court a couple cases ago, right? You only have to show some harm. It doesn't have to be significant. Can you imagine? Clearly, this case would also be reversed today. We'll see where this ultimately ends up, but yet something I think that is particularly helpful as well. Moving on to our 10th case, let's return to the 6th Circuit for all of you in Ohio. Here we go. Let's talk about Fisher versus Airgas. Now, here we have a situation where this is all about the ADA and disability discrimination. In fact, I can't even remotely make up these facts. So bear with me. Let's hop into them right now. All right. Plaintiff works for Airgas as an operations technician. After a while, learns that they have liver cancer. Fisher goes and gets treatment, but continues to work. Doctor says he needs surgery. He's out for 8 weeks, comes back to work. Everything seems fine, but he's in pain, through the day because of his cancer and because of the results of the treatments. So a former employee comes to him and says, listen, there's this free hemp type of stuff. It's worked for me. It might work for you. You might want to try it. Fisher tries it. And there's no policy that says you can't use it. It does seem to be somewhat effective. And then Fisher gets called for a random drug test. Now, sample comes back, allegedly to Fisher, testing positive for marijuana. The vendor is higher right. Plaintiff is going crazy. I did not ingest. I didn't have an edible. I didn't smoke THC. Denied marijuana use altogether. Explained that maybe it was this free hemp thing, but he doesn't know. And now he's talking to people at Airgas, right? It says maybe it caused a false positive in the test, but at the end of the day, you got to retest. This is totally wrong. Airgas says, fine, we will retest using the same sample. Airgas never talks to Higher Right and any of their folks about the free hemp use information that was provided by Fisher to them. Airgas also doesn't ask Higher Right whether free hemp might cause a false positive on the test. Concurrently, Fisher's so upset about this, Fisher contacts Higher Right, gets somebody in the medical review officer realm to talk to about this and discusses what's going on. And this Higher Right employee says that he actually didn't test positive for THC. He tested positive for THCA, which is something different. And that, it really should be okay. Of course, the original test done by Higher Right comes back again positive, and Fisher's terminated for, of course, marijuana use that he didn't have. So then Fisher shares what the medical officer at Higher Right said about the free hemp, and that they mislabeled the original test to begin with. And Airgas says, well, we talked to their chief medical officer, and that medical officer says that, it contained THC and that legal hemp wouldn't cause this. And so it was appropriate. District court throws out the case saying that there was no pretext at all. Okay. Fisher, of course, appeals. And the appeal is because, come on now. Airgas turns around and says, listen, the head of Higher Right says it's totally plausible. We fired him based on that. So under the honest belief rule, we should get out of this. So the Sixth Circuit gets this bad boy. Timing is everything, friends. Sixth Circuit pretty quickly says, listen, no, you're not, the summary judgment motion, this is not standing. And by the way, your honest defense, honest belief rule defense, that's great. But guess what? You got that information after you fired him. He got his information before and told you about it, and you didn't do anything about it. And he told you about the free hemp, and he told you about other stuff, and you took no affirmative action with your provider to determine whether or not what they were talking about was correct. Why not? You just didn't bother. Now, friends, I'm not saying that we shouldn't have drug testing, but for the love of God, if somebody's going to say something, we all have to take reasonable steps. Clearly, that didn't happen here. Hopefully, this is a good example that will help you prospectively. Now, going through 10 cases, I do have some more thoughts to provide to you. But before we do that, I would love for you to do me a favor. I'm going to give you a minute and a half or so. If you'd be so kind, here's what you do. If you take the camera on your phone, point at the QR code, okay? And it'll give you the link right into providing me some quick feedback that let me know how I did, what worked, what didn't work, all those kinds of things. All right. If you're on your computer and you want to just, go to the site, That's also listed here. The code's listed here for you as top 10. All right. Give you a minute and a half. Really appreciate you taking time to help me up my game prospectively as we talk about the top 10 employment cases of 2024, helping you out here in Ohio. Oh, and I almost forgot. When you take the time to do this, you will even be provided with an additional downloadable item, which is when we talk about some harms under the Muldrow case, what are some of the things that could be included under the title of some harms? And I have a PDF for you just on that issue that will be provided to you along with the list of the cases from our top 10 this year. Thank you for taking time to do this. All right, so I want to provide you the opportunity to continue to do and complete the evaluation in order to get the additional information for you that I totally want to provide. But I'm going to keep going, make sure I can finish up here for you. You can always hit pause till you're done and then finish watching this at your leisure. So here we go. There are a couple things I want to make sure that you're aware of as we wrap things up today. Of course, we were talking about the top 10 employment cases and why they even matter. So let's talk about them because there's a lot to do right now as it relates to the top 10. The first thing, of course, relates to AI and the need to make sure that you take a look at the agreements that you have with your providers because this stuff is happening at a breakneck pace and you don't want to be left holding the bag if there's an calculated issue with an algorithm or anything else related to the AI issues impacting your business. Next, we talk about some ADA items, particularly related to what documents have to be completed, how they need to be completed, and in what way they come back, including being signed by a medical provider. Then we talk about, well, employers that are being a little bit too aggressive. And so let's remember, right? After that settlement's done, be careful about who says what, how, and when. Next, we talked about the fact that even though you are under the FMLA, the company policy still controls. If there are procedures for call outs, if there are procedures for coming back to work, they still have to be followed in order for things to work prospectively. And it's important for an organization to have that stuff locked down so that you don't have a problem going forward. All right, next, we got that virtual data issue, right? If you're doing a lot of virtual stuff, if you're hybrid or a virtual organization, you have to know what you're getting and what information is being captured by doing all of these virtual interviews. It becomes really important because you just never know where folks are, and you can't just be worried about federal law. You also have to be worried about state and local law that may be impacting the very data that you are overtly or inadvertently gathering during an interview. Next, we're going to talk about a little bit of, well, the tsunami that's coming as it relates to some harm under Title VII and the kinds of things that may be covered, which of course are part of the gift that I have for you for completing my survey. All right, then we're going to talk about accommodations and about how it ain't all about the employer, and the employer needs to be more assertive in understanding when folks need to have assistance. Sometimes helping them out instead of having them work a 53-hour work week is a better move than not. Next, even when we're talking about FMLA, investigations still need to happen because people can still do stuff and they're not protected in their job anymore while on FMLA than after or before FMLA leave. Seems kind of basic, but still something to be reminded about. All right, next. Copeland is a train wreck. It was a case that even reading turned my stomach, but it lent itself to having a really good opportunity for people to appreciate you got to do the investigation, you got to do it right, and it's got to be done as in-depthly as necessary to come to the right conclusion. That's how you make sure we stand up for our employees and are an employer of choice going forward. And lastly, there are no shortcuts in a drug test. You got to make sure it's done right. And if somebody balks about something, we need to follow up on it, because honestly, it's generally cheaper to work it out with an employee than it is to think about the ROI to bring somebody else in and get them up to speed. Now, I hope this top 10 was helpful to you, and I hope that we're able to continue to connect prospectively. I would love to connect with you. Feel free to reach out. If you have other questions, don't hesitate to reach out. Thank you so much for joining me, and I hope you've enjoyed this value-added bonus for being with us virtually here at the Ohio SHRM Conference. Have a fantastic day, and I hope to see you again in the not-too-distant future. Have a great day. Bye now.